by culture, religion and language, and from that it's not obvious that it's have a huge impact on land and natural resources, but for sure it has, because the UN Human Rights Committee, which is the monitoring body, has interpreted culture also to mean the basis of the culture, which can it's the livelihood, land, and so on. In other way, both marine resources in the ocean and land arise to use the land. So that makes it important, and from another point of view, the provision is rather widely written, so it's not easy to see what he covers. Therefore, the monitoring body's interpretation is of importance. And one of the important statements is that the committee observes that culture manifests itself in many forms, including a particular way of life associated with the use of land resources, especially in the case of indigenous people. That right may include such traditional activities as fishing and hunting. So this is from the Human Rights Committee's general comment written in 1994. It shows its importance, but it's not the only sources who pointed that way. There is also several cases raised by individuals where the committee conclude in the same way. I will not spend more time on the international practice from the Human Rights Committee, because I suppose it is known by many of you, and if there is more question about it, I'm sure that Rachel can elaborate on that. I will instead go to the practice from Norway. In March 2017, case placed the provision heavily on the agenda in Norwegian indigenous people law. The case concerned the authority of the Ministry of Agriculture to reduce the numbers of reindeer, in other words, to impose forced slaughtering on reindeers, belonging to a Sami reindeer herder who carefully was working to establish a substantial reindeer herd for his livelihood. I probably should add that there is a program in Norway to reduce the quantity of reindeers. Reindeers, as you know, is the most culture-specific livelihood for the Sami people, and the authorities, the Ministry of Agriculture, have come to a conclusion that there is too many reindeers according to the pasture which exist in the Sami areas, and then they have found it's their duty to reduce the quantity of reindeers from ecological reasons, but of course also from culture and economic reasons. If the pasture is destroyed, it will also come to a ruin for the Sami culture and also for the economical income from that. So from a general approach, this it's how to say, it isn't aimed for that then let's go further on with the court case. I will point on two important things which the Court of Appeal. I have to say that this is not a Supreme Court case, but it's held by two instances. First, the District Court in the Sami area, in the Finnmark Court, and the next one is the Hålogaland Court of Appeal, which cover the northern parts of Norway. And also, it's of course of interest that this case is appealed to the Supreme Court, and it will be here there in December. So the first things we can learn from this court decision is that there is a threshold for when an encroachment in the possibilities to enjoy or to exercise culture is violating the provision. And the Court of Appeal, they, among other, discuss the human rights practice before they go into the particular case. And from the human rights praxis, they found that it's not lawful that reindeer husbandry as a traditional Sami activity is a culture exercise protected by the ICCPR, Article 27. Article 27 protects the Sami as an ethnic minority and provides individual protection for activities exercised as a part of the minority's common culture. This means that the individual reindeer owner cannot be denied the right to exercise reindeer husbandry. There have been at least two other cases here by the Human Rights Committee which is referred to here. Among other, it's shown that even if it can be considered as a dispute about the pasture between the reindeer herder, this is a case which can be addressed to the state and which the state needs to, clean up in. So the state party's responsibility has been engaged in this case by virtue of adoption of the Reindeer Husbandry Act. This is a statement from a Swedish case from 1998, the Kittok case, but the Hålogaland Court of Appeal in Norway use it with a reference to that case on this recent case in Norway. And then you come to another case law from the Human Rights Committee, the Angela Poma case against Peru, where the norm is that the provision, the Article 27, have been violated if the person not is able to have any income from the livelihood. In the Poma case, it was a question about llama farming in the Andes mountain, where the water construction system deprived the land for water, so many of the animals in the livestock was dying. In the case from Norway, it's not any intervention or encroachment to destroy the nature, but actually it's a decision from the authority to cut down the numbers of reindeer. And there is a common understanding that to have a normal income from reindeer husbandry, one needs case we are looking at here, it's by the way referred to in Norway as the Josef Ante Sara case, which is the name of the reindeer herder in the case. And for him it was the question, he had 114 reindeers, and the Reindeer Husbandry Act say if it's too much reindeer, there should be a proportional cut down for each of the members of the reindeer herder community. So if the big reindeer herders, who probably could have 500 reindeers, had to cut down with 10-20%, also Josef Ante Sara, who had only 114, had to do the same, then ending up with 75 animals. There is a kind of strange arguing from the state authorities that it's possible to live from 75 animals, even with a better life, because there will be more food for each animal. They will grow bigger and you will get better income from slaughtering them. But that's of course something which only can happen in the far future. Is everybody could own the animals, and even in that case, this more or less looks like far out from the real fact. So the Court of Appeal in this case come to that Article 27 is violated because of the reindeer herder don't have the income to live from his herding. He can of course continue with 75 animals, but then it will be more kind of hobby for him, not a livelihood. So that was the one norm you can read from it, and I suppose that's a way the article can be interpreted. Also, if there is encroachment in the life of the Greenlanders, if they cannot exercise their livelihood, for example, by coastal fishing, sealing on, or seal hunting, or other things. Everything what is connected with the traditional life is considered to be kind of a basis for exercising culture. There is one more point to learn from this case, and that's for the first time it's implemented in Norwegian law, but that's also developed from the Poma case. This we have go through, so I will come to the next one, and that's the question about participation in the decision-making process. The Court of Appeal found that if not a representative body of the Sami people have participated in the decision-making process, and not only participated, because the Sami parliament had participated in or was consulted when the Reindeer Husbandry Act, the law who allowed the reduction of reindeer, was made. But as you can see here, in the Poma case, they come to that it doesn't require only consultation, but the free, prior and informed consent of the members of the community. And that wasn't the case with Josef Ante Sara, so the court come to that Article 27 was violated from another reason too, and that was that ministry or the authorities, they had not required the free, prior and informed consent from the Sami parliament to establish that kind of law. case shows that intervention in traditional indigenous livelihood cannot be done in such a way that individuals are deprived the opportunity to have an economical substantial outcome of their industry or their livelihood. And the next one, the furthermore free, prior and informed consent from a representative body of the concerned people must be obtained before such decisions or law authorizing such decision can be adopted. And as I have shown you, this is the interpretation of the Norwegian Court of Appeal is more or less only based on interpretation of case law or practice from the Human Rights Committee, which is the monitoring body for the ICCPR. So it means that the way to understand the Convent or the Article 27 should be in case of international understanding. So this is not just a question for Norway, but for other countries with indigenous people, and the ICCPR is ratified and incorporated in most of the countries worldwide. So and also the question of the legal authority for the provision in Norway. It is incorporated through the Human Rights Act in Norway from 1999, which say that the Article 27 has precedence in front of other internal Norwegian legislation except for the Constitution. Yeah, so that was what I had planned to speak about, so thank you for the attention.
So Rachel, while you were writing Øyvind that we are grateful for his e-presence, I need to stress that unfortunately we can't ask questions. As you noticed, we can't talk to Øyvind. So we will move on to the next speaker. We just ran out.
This is just to discuss here. If we stretch it and say that we are talking about indigenous, and let's say that there's a hunter who has a sustainable livelihood of hunting, let's say narwhals or guillemots, who are or one of the endangered species, and the government says, okay, no more hunting of those. Are we violating? Where are we there?
So what comes first, animals or people? Is that the question?
When are we violating this?
Yeah, and there is a bunch of international law also on that, and one of the issues would be about who gets to provide the information, who gets to provide the knowledge, and I think the indigenous people in the Arctic would tell you they have never hunted a species to extinction. and we should be paying a lot more attention to their traditional knowledge, their experience, and listening to them. So there's a case in Canada about the narwhal where we have a bunch of experts coming in and telling them that there aren't enough narwhal, and they cut the quota quite significantly, and a protest against that, an appeal against that. And if you actually look at the scientific evidence they had, it was based on 2 people on a plane looking out the window and counting whales, which is the best they've got, but it's clearly even the scientists admitted that this was not a terribly efficient method of counting whales, but they were not really, you know, they give lip service to it, but they were not very good at integrating the Indigenous knowledge. I'm not saying Indigenous communities, Indigenous hunters can never hunt species to extinction, that is not a possibility. But if you look at Indigenous traditions that go back centuries, millennia in some cases, it's not in their interest either to hunt this species beyond sustainable levels. And if we think about the culture attached to traditional hunting, it is about taking just what you need and not taking more than is acceptable. So I think we have to not just look at Western science, but also integrate that Indigenous knowledge in decision-making process. We need to keep moving on.
This case of the reindeer herding is very interesting because I guess that Norwegian law talks about sustainable use of living resources, and there's a clash between this reindeer herder and the sustainability. I know a lot about reindeers. I've been working with reindeers here in Greenland. So if you have overgrazing in the Arctic and the subarctic, the vegetation will return after about 100 years. So if you have overgrazing in an area, then the total economy in the area is destroyed for maybe 100 years. So this this decision that you can overgraze unsustainable, looking at the vegetation, will probably destroy the whole economy in the reindeer herding in the area. So we have a clash between Western sustainability and the economics of the reindeer herders. So I can suspect that the whole herding in this area will stop because you have overgrazing. So the clash between Norwegian law and indigenous people law is so clear here that you have to make a compromise. You cannot allow unsustainable, when you look at the vegetation and the amount of the grazing pressure on the area, just to allow him to have his economic sustainability for a short period before the overgrazing takes over. So it's a very interesting case. Should we look long-term sustainability and economic sustainability for a long term, or should we say, okay, this is indigenous rights to overgraze? Is it? It's very exciting, like the narwhals. When you have Western science says we have to have a quota and have to be sustainable for a long period, or do we have to see? And you talk about we have never extirpated any species in the Arctic, but that was before we had fast motors, rifles, large vessels for hunting whales, for hunting seals, narwhals. So it's a very interesting question. Who is going to have the last saying? And the reindeer herding is very interesting here.
One back.
No, just let
I'll respond briefly because I'm neither an expert in reindeer herding nor in Norwegian law, but it's about, if we go back to free, prior and informed consent, he clearly didn't give consent. If there had been a better dialogue, better participation, and better information going both ways, both listening, and there had been better agreement about what would happen if he was no longer able to herd reindeer sustainably, what alternatives were available to him, that is something that with perhaps a longer period and better faith on the part of the decision makers, they might have actually reached a consensual agreement. So it's not just a case of Indigenous people being allowed to do exactly what they want because they've always done it. It's about trying to balance these interests through a dialogue and not just saying, okay, we get to decide, that's it. Neither side just can say, this is it. We really need to keep moving on.
know Rachel already said that then it's the dialogue before making the decision that I was going to ask about. But also, as far as I can understand from the herding case, it's because if you're going to be able to have a sustainable or stable economy, you have to have at least 200, 300 reindeers. And maybe there are a lot of reindeer herders with a lot of, maybe 1,000 reindeers. So there, you have to find a balance and dialogue, just nothing more.
Yes, I agree with that, and because I have spent a bit of time in Norway, and I'm very aware of not of the actual facts, but the fact that there are scientific ways of assessing reindeer sustainability and indigenous ways of assessing reindeer sustainability. And there's also a lot of other pressures on the land. So rather than saying you have to kill all your reindeer, perhaps consider all the roads and wind farms and everything else that's being given permission on the same land. So there are lots of issues, and I think that what is lacking in that situation is the dialogue. It's bringing people together to talk, because otherwise they're going to be standing on opposite sides going, this is the scientific fact and this is what the reindeer herders think. So I just wanted to agree with that.
Hi, just a minor comment which can go back to the natural resources. One principle that you have in most agreements in petroleum law, you should not extract to damage the maximum recovery. So actually a government can intervene and force you to do otherwise. One example, imagine for example you have 2 blocks in a particular country, and these 2 blocks share the same reservoir. That used to happen a lot in Texas. So what would you do in this game theory? That I'll go to the border to try to drill as much from my neighbor. And imagine you have in US 50,000 people doing the same. So everybody going to the neighbor. So what you do, you're damaging the whole reservoir because everybody's drilling like crazy. So that's why in a similar manner here, you should use the best ultimate recovery that can last longer rather than just drill as much as you can. That's going to actually have a shorter life. Instead of last for 50 years, it's going to last for 15 years because you actually drilled in a non-sustainable manner.
Thank you very much. So now this is not so much the skeptical lawyer, but the human rights lawyer. I think this is a very, very, very interesting case because it also brings to the fore that very often when we talk about human rights issues, we have several competing interests. And it is really such an important act of balancing these interests against each other. And again, then what comes back to balancing is very much in the argument, of course. And then maybe that goes back to one of the things we were discussing this morning about who then has the strength to deliver the best argument, and who has the access to the resources to get say expertise. This can be from human rights experts, or it might be from lawyers also, to develop the argument that really best protects their own interests. So sometimes again we have this, on one hand we have certain interests that want to dominate the case, and on the other hand we have the need from the perspective of society to really balance interests so that everybody becomes happy. And this is one of the very, very challenging issues about human rights, where we do not have square answers, and a very important case like this serves an important issue of drawing attention to the rights of indigenous peoples in the high north. But on the other hand, it also still has to be considered in light of what other needs do societies in which these people live have. So I don't think. I certainly don't have an answer to this, but I think it's to see how we deal with these issues. It can be very, very good to look at how these human rights conflicts get balanced in so many other contexts where there are 2 human rights competing against each other. Thanks.